So this is the third and final part of the Fenwick presentations to the Denari Labs incubator. It's been a privilege to be speaking with you guys. I'm looking forward to continuing these conversations. As a reminder, Andy, co-head of our blockchain group. I'm Ben, senior associate in the group. And today's focus is really on the interplay between fundraising and tax planning. So if we were to take a step back and look at how fundraising traditionally happens in a Web2 ecosystem, the steps that are required are: one, you incorporate or create the entity, right? Typically that's a Delaware corporation. You can incorporate in another state if you want to. You can use a different entity structure, but typically, what we see is a Delaware corp. So step one, incorporation. As part of that incorporation process, the founders will contribute whatever IP they've developed prior to incorporation. They may pay some nominal price to get equity in the business. And so the company will be owned by the founders. And once you have a company that's owned by the founders and the rest of the initial employees, to the extent that they're supposed to get equity, then you proceed with the fundraising, right? And you have investors. They may purchase safes. They may purchase equity in a priced round. They may purchase a convertible note. But relatively straightforward for how you think about the financing process in Web2 land. The purchase of equity by the founders or by the investors, does not give rise to any sort of taxable event for the company. You take a look at what's happening in Web3 land, and it's a lot more complicated, right? And so this is just one of our models. It's not our only model. And just reiterating that we're not giving legal advice on this. This is really just for informational purposes. But if you look at the right-hand side, the launch partner, U.S. service providers, the blue and the equity investors, the blue boxes on the right is the entity structure that I just covered on the prior slide about Web 2.0, right? Everything else exists as a product of the regulatory challenges, trying to solve for tax issues, trying to mitigate on the regulatory side, not just securities, but also VASP, potentially other regulatory regimes that we covered in prior conversations. And so it's a much more complicated structure. There are a lot of issues that we're trying to solve for. And a lot of times when you solve for one issue, you've realized you may have given rise to another legal issue. And so it's really a matter of trying to mitigate all of the regulatory, tax, and other risks as much as possible. And I can say that tax considerations is a major driver of this model. And so, again, the blue column, the blue boxes are what you're dealing with in Web 2.0 land. This Genesis Foundation in the middle is a lot of times we use a Panama Foundation here, but there are other jurisdictions that work. And the idea is that this is the entity that is responsible for deploying the smart contract to launch the tokens and deploying the protocol. And that's really all that it does. It's a special purpose vehicle. And then this token seller subsidiary sitting below it, typically that will be housed in a BVI, but we use other jurisdictions there as well. And one of the features of the Genesis Foundation is that it's a non-commercial entity, so it cannot engage in commercial activity. So you need the token seller subsidiary sitting below it in order to take certain commercial actions. And the main commercial action that this entity takes is being the seller of the token interests before the tokens even exist in the first instance, for purposes of moving around tokens to the founding team and at times early investors in a transaction or a series of transactions that we refer to colloquially as the founder round. I mentioned that a lot of the structure is driven by tax considerations, and the main tax consideration that we're dealing with initially is how you get tokens or token rights into the hands of the early dev team and other contributors before those tokens even exist, when the fair market value of those token rights is very low. And the reason why we have to worry about that, where we don't necessarily have to have these same considerations when we're dealing with a Web 2.0 company, is that the movement of token interests and the purchase of token interests, these are all taxable events, right? So whereas if an investor or a founder is getting their initial equity in the business and they're not, that's not taxable. Founders, they do it pursuant to the 351 exchange that we've talked about previously. Investors, when they're purchasing equity, that's just not taxable. And so it's just a different consideration of you need to get these token rights to Delaware in the first place, right? And we don't want Delaware to be the issuer of the tokens because, as we previously discussed, if a centralized entity is creating the tokens, then what you've created is a centralized convertible virtual currency, and there's no way to change that in the future. And that means that you need to comply with the BSA and other anti-terrorism, anti-corruption laws that are on the books. So the founder round, again, is really a way of allocating token rights to the founding team initially. And this whole structure that we've drummed up, driven by tax considerations, but also regulatory concerns as well. And then the entity on the left, this DAO wrapper, we've been using Cayman foundations historically. We're starting to also see some interest in using Marshall Islands DAO LLCs. We've used Swiss associations, but we've run into various issues there. There are a lot of different structures that we can use for the DAO wrapper. That is the entity that eventually, post-token launch, will serve as the long-term governance foundation for the DAO and for the ecosystem. And yes, I see that you came in wondering if there's anything you want to contribute here.
Yeah, a couple of things I guess I just add to that. On the centralized convertible virtual currency, there's a concept of an administrator. So what Ben said is absolutely right about OFAC and all those kind of things, but we generally comply with anti-money laundering laws anyway voluntarily.
Right.
So it's not that you're not complying with those things. We do. A centralized convertible virtual currency is an administrator as defined under the Bank Secrecy Act, and that would require registration as an MSB at a federal level and in the 50 state MTLs, and you literally would not be able to comply with those requirements. So while at an application layer, at a GUI layer, we can comply with OFAC screening and GeoBlock and do all those kind of things, you literally would not be able to, for example, track holders and file suspicious activity reports on transactions over $10,000 on chain. There's just no way to do that on like Ethereum or any layer one Solana. It doesn't matter. There isn't a way to do that. And so it's not a matter of saying like, look, I have all the money and time in the world, and I want to fully comply with every sort of virtual asset service provider globally. I want to comply with every US law, Bank Secrecy Act. Given the nature of the technology, you literally could not. And so we have guidance from FinCEN from 2013 and then updated in 2019 to create this concept of decentralized convertible virtual currency. In the space, we refer to it as the Bitcoin guidance because it was written in response to Bitcoin. If you look at how this is set up, it kind of resembles Satoshi as the Genesis Foundation, and then the DAO wrapper being a different non-issuing entity, sort of like the Bitcoin Foundation in the early years, advocating for miners and sort of building social consensus. It mirrors that. And so we're trying to create decentralized convertible virtual currency in a manner that is consistent with that guidance that we got from FinCEN in 2013 and then updated in 2019. So there's a bit more contours around that. And then as Ben said, so it's a multi sort of legal regime strategy here, create decentralized convertible virtual currency, right? Don't have an administrator. then tax optimization, as he said, through those series of what are prepaid forward contracts. The other thing too is through that assignment mechanism, we're going to create a property interest. That's number 3 on the screen right now. And that would enable you to file 83Bs like you would if you were forming a new company. So these are really critical steps. And I would say that when we're pulled in to fix things, later stage protocols that are about to get to launch, realize they have some issues, this is what it tends to be. And they tend to have very large, what we call phantom or dry tax events, where people are having completely unacceptable tax outcomes without the movement of fiat, hence the term phantom or dry. So I've had examples where I've gotten pulled into $1 billion network, let's say, based on a financing. And they say, hey, look, we want to move 10% of the tokens to our Delaware company or 10% of the tokens to our founding team. All right, that's $100 million on your income statement or W-2. And you all will say, if you're in California, right, or New York, highest income state tax, you're going to owe Uncle Sam, call it $50 million in fiat. Next day, withholding obligation, right? So that doesn't work. So these are not just academic points. In particular on the tax side, these are nuts and bolts, setting things up right from the very beginning. And if you don't do it, it can be a bankruptcy event for the individuals and entities involved. And sometimes I can mitigate the damages and that sort of thing. And sometimes I can't. And we have to come up with just other structures where people don't get the value that they otherwise would be entitled to. So I'll pause there. There's a lot going on in this chart and lots of issues going on under the hood, but that's kind of the 5-minute tour of how these initial designs take place.
Is the takeaway that you would want to do all this structuring work before as early as possible with respect to a token launch?
It's a great question, right? So as a lawyer, I have to talk out of both sides of my mouth on this one. All right. I want you to do both. I want you to take as much time as you need, and I want you to do it immediately. Let me explain why. All right. The easy part, we've talked about doing it immediately. There's no transactions that have implied a price, whether it's a financing, whether it's a partnership, whether it's a listing, whether it's any contract that would imply the price. So get it done quickly, right? Lower chance for there to be value creation as you're developing technology and causing, just value that would come into that third-party valuation where we value these things, kind of like a 401(a) valuation. So do it immediately. So what is the other side of my mouth where I say take as much time as you need? The answer to that is you have one chance to do this. That's it. It's one of there aren't that many irreversible decisions. This is an irreversible decision because once you lock those in, they're contractual obligations that need to be honored to the various people. You're setting your token allocations for your airdrop, for your community allocation, for partnerships. Those cannot move into different buckets without taxable events. And so on that side of my mouth, I say, don't do it until you're ready. Right? Don't do it until you've thought through everything and you're absolutely ready. I'll give you a quick war story on that. I have one that's a later stage company. We set our founder round allocations. And then over the subsequent 12-month period, we did 2 buy-side M&A deals at the launch partner level where they wanted tokens to use it in that M&A deal. And each time I had to say, guys, this is why I said to take your time and be really thoughtful about it. Because every time we move the tokens over to the Delaware company, reallocate them to do that buy-side M&A deal, that was a taxable event. And so when they were factoring in the cost of that acquisition strategy, they had to factor in the phantom tax they were getting at the Delaware company level for each time we moved over tokens. And so, and were those predictable, not predictable? That's a hard decision. And so as a practitioner, I have to ask you to get your crystal ball out. Well, we all know none of us have a crystal ball. And so what I try to do is go through a rigorous and analytical process, flag all the potential things that I've seen. I've touched the stove 100 times and been burned. Let me warn you, don't touch the stove here. It hurts. Think about those types of things. And then what we're trying to do, here's where the art comes in. We're balancing the early part of that side of my mouth. I want to get it done before there's value and before you need to do a transaction. It's going to have a pricing event. But I want you to take as much time as you need to make sure you've got as much data and insights into your model design and your tokenomics to where you're not going to change the number, right? And so what I frequently do is have the early conversations with people, have them start thinking through the spreadsheets, talking to other advisors, consultants, whatever they're going to do. Folks like Horizon frequently are involved in that conversation. And then identify, here's the things that could cause a valuation event issue, a financing, a listing, just a bunch of different things. When in your life cycle do you anticipate running into those when you're going to need to do that event or want to do that event? And then let's back up from that and know that we have to go at least, 3 weeks to a month, 6 weeks before that. And so that's kind of your drop dead date. And then as the business leaders, as the entrepreneurs, you can turn those knobs, right? You can say, all right, we'd like more time to make our decision, and we would delay one of those transactions, right? To allow time to do this, to think about it. Or you can say, no, we got to be ready to go at time zero as soon as the window opens or whatever the market-based opportunity is. So we're going to pull that work forward and take more risk on the not having every token in the perfect bucket, and we'd rather take that risk. So this is where it really is art and not science, and people make different decisions. And there are frequently times where we complete a founder round and then things change, including like a financing. It's not always just, hey, we wanted to do a buy-side M&A deal. It's like, oh, we actually decided to raise another round and the investors want tokens and equity. Okay, well, we didn't plan for that financing, or maybe we planned for a smaller financing and now it's larger, or vice versa. Because you're not going to know, right? You have to make a lot of guesses. That's the crystal ball angle. So not a great answer. I wish I could tell you, like, here's the answer, but that's the process to get to the right answer.
Just a couple of additional points there also. Andy mentioned you need to understand how much is going to the airdrop, how much is going to the general community bucket. That bucket itself will be segregated, right? Because some of it will be used for ecosystem growth, some of it may be used for partnership deals, whatever it, marketing spend, etc. You don't necessarily need to know what each sub bucket's allocation is at the time that you're doing the founder round. Okay. You should just have your have like a pretty firm understanding of what the aggregate community bucket is, and then you can toggle those line items pretty easily. That doesn't give rise to any tax issues. The other thing to mention is that given that moving tokens from the offshore Genesis Foundation to the launch partner is a taxable event, when in doubt, we have advised some, but not all of our clients to over allocate to Delaware, the launch partner, knowing that if you end up having a surplus at Delaware, you can later contribute those to the Del wrapper. Having that over allocation to Delaware puts some stress on the model as far as security is concerned. So that's something to think through depending on what the overall allocation is that's going to the launch partner. But it certainly addresses some of the tax concerns if there's uncertainty whether you're going to be raising another round and you think there's going to be token exposure, if you're going to be doing some sort of M&A activity where part of the consideration is going to be tokens. So it gives you a bit more flexibility so that you don't need to have as clear of a picture with your crystal ball.
It's a great point. And let me explain the why a little bit and broaden it. So when in doubt, right, there's always that gray area at the end. I don't quite know what to do with this 5%, 3%, whatever it is. We always want to move it to the taxable jurisdiction up front, because you're never going to be able to get it into the taxable jurisdiction later in a cost-effective way. But oftentimes you can go from the taxable jurisdiction to a non-taxable jurisdiction. Yeah. So, US with a contribution to Cayman typically works. As Ben said, there's other considerations. We want to be perfect, but if we know we're not going to be perfect, that's the way that we do it. And so if you have a UK centralized company or Singapore, any jurisdiction with a robust tax regime, default is move them in at the low basis, because we're going to be it will be a better chance that we can move them out later if we realize that was the mistake, as opposed to leaving them in Cayman and then going, oh, we got to get them into the US. The river doesn't flow upstream well.
Yeah, you can. I'm curious, how long does this process take from start to finish, in a perfect world? Obviously, results may vary, but what's a good amount of time for teams to budget?
I would say one of the biggest long pulls when it comes to the founder round is coordinating with local counsel, because we need to set up entities, the Genesis Foundation and the token seller subsidiary, Typically, one is Panama, one is BVI. It takes some time to do the KYC onboarding and to actually get those entities formed. I would say the other long pole is actually figuring out what the token allocation or token right allocations should be for the founder round. Once those decisions are made, once the entities are formed, we can execute on this very quickly. And then, as Andy mentioned, it's just a matter of building in this quiet period. Our tax colleagues have recommended a bare minimum of 3 weeks. Obviously, the longer, the better. And given that the fair market value of the token rights that are purchased in the founder round is typically very low, our colleagues really like to see some sort of intervening event between the closing of the founder round and token launch that substantiates why at token launch the price per token is significantly higher than the value of the token rights that are pre-sold in the founder round.
And the other thing that drives the timing is volume, accreditation, and jurisdictions, right? So if you told me there's 5 names on the spreadsheet and they're all US and they're all accredited, lickety split. We're going to do Reg D, accredited, not a problem at all. One jurisdiction, not an issue. I've done some later stage companies with a pretty global footprint where we had 300 employees. We had 8 countries, and I'm on the horn with Icelandic local council figuring out what's the tax strategy in Iceland, right? And then the UK, and then Singapore, and you got because you got all these different, and so that that one can take a couple months to work through everything. And then also on the accreditation side, if they're accredited, easy. If they're not, okay, you can have up to 35 unaccredited. And what we do is a PPM, private place of memorandum, is a disclosure document. These are very early stage companies and models, so that can be kind of intimidating. But the reality is there's a lot of stuff that's not applicable. So we can actually bang that out relatively quickly. And then you need a purchaser representative. So somebody that is financially sophisticated that can read the disclosure materials and answer questions, sort of represent the purchasers in that. So the mileage varies based on the team and making decisions and what you want to do. And then volume, accreditation, and jurisdiction. So anywhere from quick phone call and we're going to bang all this stuff out and get to work to I've had some with, 300 employees where I'm on, all hands calls around the globe, fielding questions around different jurisdictions and what those are. Those are just very different processes.
Yep. And just to put a number on it, I would say probably worth budgeting 2 months from kickoff of the founder round to closing. And then there would need to be a quiet period, and then post quiet period, there could be other token pricing events prior to token launch at that point, or you could just proceed with launch.
I mean, that logically makes sense.
But I guess I should add one thing that we did not really discuss is the DAO wrapper, as far as that's a separate work stream as far as getting that set up, figuring out what token holder governance looks like, if there are any directors, security council members, whoever it is, what that composition is, what their relative rights are vis-a-vis the token holder. So a lot of considerations there. The 2 months is really just focused on the founder round process. And I guess the one other note is that we don't often see this, but you can run the founder round process and setting up the DAO wrapper concurrently. They don't have to happen sequentially. Okay, moving on. When it comes to fundraising, again, one of the differences between Web 2 and Web 3 is Web 2, the investors are typically only purchasing equity or some right to equity in the future. Whereas in Web 3, unclear where the value in the business is going to accrue. And so investors will want to have exposure to both equity or equity rights and token or token rights. The exact structure of the fundraising depends on the stage of the company. So typically, as Andy hinted at and we've discussed, you do not want to actually be selling tokens and pricing the tokens before you've completed the founder round and ensure that you've allocated or purchased token rights at a tax optimal price. Because if you inadvertently price the token network first. I mean, there are some things we can try to do to solve for that, but a lot of times it leaves the founders in a pretty unfortunate position.
So for a model that's not going to have any equity value, let's talk about like a protocol. Let's pick like an L2, right? Theoretically, the centralized company is going to be building what's going to be open source technology. All the investors really just want the tokens. In the early years, I would do a lot of token only financings, right? Call it, there's the tax issues that we talked about. I'm going to circle back on those, but I want to talk about some strategic points first. 2016, 2017, we did that a lot. And what happened was there were models that moved around, right? Hey, we told the investors it was going to be a token only play. It's a labs entity. And then you wake up in 6 months, 9 months, a year, and there is some equity value. We built an application layer that's going to have a fee rake on top of it, whatever the model is, or we just pivoted. And the investors felt like, pardon my language, they got screwed, right? Because there was some value in there and they only got exposure to tokens. And now there is sort of value creation there. So those were the very early years. I think investors kind of got burned by going with the token only model there. And it would make sense intuitively with a layer 2, but there's obviously different variations from there to like a heavy application layer system, like a game, right? So a lot of variability in there. Then what happened was I was still trying to do a lot of token only raises because I think it's great for the founding team because they get to completely control their centralized company. And we would do deals at the time that were like common stock and SAF deals. And the investors had wisened up and they said, look, if we get to the end of the road here and there really is no application layer value, then I will happily sign the stockholder consent dissolving the entity. But I want it to be schmuck insurance. So you guys can't backdoor us and like shift value from the tokenomics over to the equity value and have us lose out. And so I started doing deals that kind of looked like that, right? And so now fast forward to today, in what I would consider to be the standard. And in Web3, I hate even saying that things are standard because nothing ever is. And people that say that usually don't know what they're saying. But so the closest thing we have to like, this is ordinary motion is insert equity deal. Could be a safe, could be Series A, Series C. I can play with any of those things. And then token warrants. And there's this token side letter approach as well. And that's the closest thing to like standard that I've seen in the space at this point. And that's how we got here, right? And so the evolution is really important. Like that's why that is the way that it is. And so I frequently have companies now, they're like, hey, look, I'm just going to keep using L2 as an example placeholder for the concept of no intended application layer value. They go, hey, look, we're an L2. This doesn't make any sense to us. And so that's why it is the way that it is. And it just sort of gives investors the protection that they want to where if it shifts. And so that's an okay thing from my perspective. I don't have a huge issue with that. It is kind of schmuck insurance, right? Now, the next box here, when in the design are you raising? This is intended to flag the founder round that we just talked about. And this is that tax issue that I wanted to circle back on. So if we are raising equity, a safe and token warrant, what we do is we allocate 99.9999 of the basis to the equity side. So people are getting the token warrant essentially for free when we allocate each dollar of investment on a relative fair market value between the two instruments, right? So the token is basically for free. So from our pricing event in tax planning, we have not priced the token. And that's how you raise a meaningful round before the founder round. So if you just did a token only financing, a SAF, whatever it is, before the founder round, you've now just priced your network. And so this is the methodology by which we preserve that tax flexibility. Hey, valuation firm, hey, IRS, people were investing in the equity, arm's length negotiation between the parties. That's how we allocated the value. The Series A got 99.9% of it. And so far, I say so far because the rules and laws and everything I work on evolves over time. So far, that has passed muster with Big Four accounting firms, auditors, like that. Like people are valuation firms. That works, right? It could be a point where it doesn't work, but right now that works. I've seen various things over the years that worked. We did them for a while, then valuation firms, whatever, changed their tune. So right now that works just fine, and that's as close to motherhood and apple pie as we get. All right, post founder round plus quiet period. Once that's done, the gloves are off. And it's in that, again, market point here, not legal point, in that I'm going to go 120 days, 90 days in the lead up to launch. That's the time in this market when you see and when I tend to do, not exclusively, but more token-only financings. I'm fine from a tax perspective. There's other more complex tax issues that come up with this, but not the ones that we're talking about here. But there are other tax issues because it's all revenue. You got to figure out what to do with it. Where should it land? And the investors are fine with it. How is this different than the original things where investors were getting burned? Because we're 120 days out. We're 90 days out. You're not early stage capital going, what's the model? We're going to go build some cool tech and figure it out. We think it's just an L2. This is, hey, we've got our DAO wrapper set up. Our founder round allocations are done, or, talking about, are we doing the MIT license or the BSL? Like, we're into like open source strategy, and this token's going to be live in 90 days. So the risk from the investor's perspective, there's going to be a pivot into an equity model. It's never zero, but it's low enough to where we start to get people that want to raise on token only, and they'll do it for the liquidity and all those kind of things. We still do venture and token after the founder round. So really, once it's founder round plus quiet period, the gloves are off. I can design just about anything. Our design space widens up a lot. And we do everything at that point. IEOs, initial exchange offerings, treasury diversification, DEX offerings, you name it, we do it, but it's got to be in that part. So there's this fundamental question of where is the value? How do we set that up? And when in the process are we talking about the financing? I'll pause there. In 20 minutes, I want to leave time for questions. I know we got a little more content, but there's like a lot more going on under the hood in this one too that we could talk about, but I want to answer questions and reserve time at the end to make sure I'm getting everything.
I think one other note to flag quickly, and I think we've actually covered a lot of the material that's on future slides, but if you go back to this slide, right, blue boxes are the centralized entity. The entity on the left is the DAO legal wrapper. Post founder round, once those token rights, a lot will be sitting, like whatever the community bucket is, will be sitting at the DAO wrapper once that DAO wrapper is stood up. There's also flexibility whether you do that token only sale or token rights only sale from the centralized entity, or if instead you choose the DAO wrapper. And one reason to choose the DAO wrapper at this stage is that if instead of going through an OTC desk at the time of launch, you have a group of sophisticated investors who want the token exposure and are willing to provide that treasury diversification at the DAO wrapper, and you can ensure that you have that lined up prior to launch, then you can disclose as part of the announcement of the token launch and of the creation of this DAO legal wrapper. Suddenly, like you have runway to continue the operations for this DAO wrapper for 12 months, 18 months, 24 months, whatever it is. And so it can be a good way to get fiat or stables to the DAO wrapper so that it isn't just sitting on the native token for the project at time of launch. So just one consideration that I wanted to add there.
Can you explain what the founder round is again? I'm having trouble following.
Yeah, so the founder round is really just the movement of token rights, not the actual tokens, to the founder team before the tokens exist in the first place. And so the flow is given that the Genesis Foundation here is the entity that's responsible for deploying the smart contract that creates the tokens, the flow is a contribution of the token rights from Genesis Foundation down to the token seller subsidiary. The token seller subsidiary subsequently selling those token rights to the launch partner, which is your Delaware corporation. And to the extent that there are investors that have rights to participate in the founder round, the token seller subsidiary will also sell some of those token rights to those investors. And then once the launch partner purchases those token rights, it turns around and assigns some of those token rights to the founders and other early employees of the company. It will also retain some of those token rights on its balance sheet to incentivize future employees and service providers. And then it may also, just as we discussed, purchase additional token rights to keep on its balance sheet for other purposes. And as we discussed, that assignment of token interests, along with some additional documentation that we include as part of the founder round, is what converts the contract right to get token rights into a property right, allowing the founders to file 83Bs in connection with their purchases of the token rights, so that you do not have taxable events every time that the token rights vest. You recognize all of those taxes up front, and then really there's just capital gains at the time of eventual sale.
So Ben is completely right, but it's very nuanced and complicated because we're solving for various complex tax issues and all these kind of things. Let me give you what I think as a business person you need to know, right? And just kind of break it down that way, right? All right, here's the analogy and why it's called the founder round. When you form, if you don't mind going on mute again, I just get just enough feedback. Yeah. Is when you form a Delaware company, it's easy. You put in some nominal cash, some IP, you get your shares back, you put vesting on it or not, and it's all tax-free. And everyone gets, the founders get, 5%, 10%, 50% each, whatever it is. You just do it. You can use LegalZoom or Stripe Atlas. It's just push easy button, not a problem. The reason why that worked so well is the way all these laws are set up and designed for forming companies. There's Section 351 that gives you a tax-free exemption. We're not worried about securities laws in that context. It's not a public offering. It's just easy. It all works. The concept of the founder round is it replicates that, but for tokens. That's it. There's all these squiggly lines and boxes and prepaid forward contracts and assignments that convert contractual rights into property right. That's for the lawyers and the accountants. It doesn't matter. You're never going to hear those terms again in your life. At least I hope not. You shouldn't. All you need to know is because the laws are not designed to accommodate just getting tokens at the very beginning to people, we had to build a complex series of steps to replicate it. And so when we say founder round, it's just supposed to be like an onomatopoeia for like you formed a new Delaware company. Everyone got what they were entitled to tax-free. And it's property. That's it. We just replicated the formation of a C Corp, tax-free, securities laws, all solved. It just had to be really complicated because the laws aren't set to accommodate it. That's it.
Boom. Wow, that made it easy.
Cool. I like a good boom. Yeah. Yeah. Anything else? In we want to be right size in terms of giving you guys nuance and details. Some founders are like, Andy, just tell me where to sign. And other people want to like get into the treasury regulations with the guidance. And so I'm happy to go up a level. I'm happy to go down a level. How else can I unmuddy any of the waters that we've covered? And by the way, we've been talking here for 47 minutes. This is content to where when I'm working with like a team and helping them make these decisions, we're packing in like multiple calls, getting into their model and helping them sort through this. This is like, we're going right into the PhD level content. Yeah, Ben, I see your hand up if you want to jump in.
Yeah, I wanted to follow up on that, the previous question and the explanation you gave. In the forming of a C Corp, you can distribute the shares and there's really no cost to it because the company has no valuation, basically. You just give it a valuation that's so low that you just you pay whatever, I forget which form it is, in the first 30 days. How can a company that has already been formed, has already done equity rounds, has a valuation, how is it possible to do I forget what you called it, the founder's token allocation? How can you do that without there being a tax implication up front, or does it have to be because there's already a company?
Great. I'll walk through it. So I want to just correct one thing. When you form a new Delaware company, this tax code 351, it's not a matter of us saying, hey, it's worthless and that's why. It's that you could put in $1 billion of intellectual property and get your shares back, and it would never be a taxable event. So it's not necessarily that it is like a low value and that's why. It's that there's this tax exemption that lets you exchange value at the time of formation. It's a limited exemption 351. But let me answer your primary question. So I'll repeat it back from the same page. How in this founder round are we getting the tokens out essentially tax-free when there's a more mature company with value? How are you guys doing that, and what's the strategy? Here's the strategy at a concept. First thing, we don't do anything that would create an arm's length or third-party pricing of the tokens. That's why we could do an equity raise and put the basis into the equity and have the token warrant be for free for a penny, whatever it is. We haven't done anything that's going to price the token, right? When we get to doing these allocations, because there's a lot of risk around this, the IRS has to respect the valuation that we set. And it's not really an arm's length party, even though we're using special purpose vehicles, the counterparty for token generation. That's why we go get a third party valuation. So Technos, Redwood, Alvarez, and Marsal, they'll come in and they do diligence, just like they would with a foreign and A valuation. And they say, all right, we've looked at the software, we've looked at, the cost to recreate methodology. They put forth, 3, 4, 5 different approaches, and they come up with a valuation, right? And it's typically very low. Part of it is that software and the token is going to be open sourced and low value. Part of it is they use a cost to recreate methodology. Different valuation firms take slightly different approaches, but the net is that we get this valuation that says the network is going to be 50 grand today. It's a glimmer in our eye, right? We are a ways out from launching this thing. Then when we go through our process, everybody pays that fair market value. Now it might be a millionth of a penny per token. And so for the Delaware company, it might be $20 or $100 or $1,000 all in. So people pay the fair market value for those. And that's what starts the clock on, I don't want to get into it too much, but long-term capital gains and 144 holding periods and those types of things. So the answer is we don't do anything that would be inconsistent. And then we go get a third-party expert to provide us the valuation through their diligence and rigorous analysis. And then we pay that amount. Hearing nothing, anything else, or did I sufficiently clear that one up?
Yeah, that helped a lot. Thank you.
Great.
Okay, let's just take a look. We've discussed the basis allocation and tax planning pieces. We just went over the methodologies of computation of the valuation of the token rates. Governance and covenants. This comes into play either at the safe level, right? So if you've raised a safe round, your investors may negotiate a side letter, and they could have some sort of block rates or restrictions on the company using IP or the exploitation of the company's IP outside of, for purposes of deploying the specific protocol, or deploying the tokens, or or causing the deployment or of the tokens or the protocol through this non-commercial entity that we've discussed. They may want some sort of control rights over what future token distributions may look like, or what token allocations look like across the ecosystem. I would say you want to avoid, to the extent possible, giving investors block rights over this process, especially if they have already received their agreed upon token allocation. And I know, taking the documents that you've entered into in connection to be part of this incubator, right? You entered into the safe and you entered into a token warrant. That token warrant promises Denari some percentage of the total token supply of the network that you guys are building out. One position that you can argue is you guys have received the economic advantage, right? You've received the economic benefit of what you negotiated for. you were ensured that you were getting this percentage of the total token supply. Therefore, you should no longer really be interested. We may consult with you. We may look to you as an advisor because you have expertise and you can help guide these other decisions, but you don't necessarily want to be giving block rights to investors. Now, obviously, some investors, it's a game of leverage, right? So some investors will demand this, and we will often agree, or our clients will often agree to these block rights. But it's always important to think about what have you already given the investors, and is there a way to push back given that they've really received the economic upside that they've negotiated for.
And this one turns on a really weird point in my experience. So there's a couple different ways that you can compute the investor's token allocation. And it really drives the governance outcome. So the traditional way to where we did it in the early years was a percentage of an inside allocation. So you'd say, all right, we're going to do 50%, 60%, whatever the number is for the community. And then whatever comes to the Delaware company, founders and investors, you're going to get a percentage of that pool. Okay. That's sort of model number one for our, I'm just going to use it as a token warrant, but there's different variations of this. Okay. So that's, and then we haven't decided those numbers when we sign the investment documents. So whatever we move over here, investors are going to get their pro rata percentage, common way to do it. Option number two is you, investor, are going to get 5% of the total token universe. You get some complexities around inflation, autonomously generated tokens, that sort of thing, but all of them that are there at Genesis. So if there's 100 tokens at Genesis, I'm just going to pick 5%. You're going to get 5%, regardless of what we do for community allocation, regardless of what we do for a centralized company. Like you investor will always get 5% of the total denominator. When we go with the first construct, investors fight their butts off on governance. Because, for example, if you sign up for that, and then the project team says, we're going to go do a fair launch, no proprietary access, no pre-mine, nothing, then the investors literally get nothing in that construct. So they're going to want to have a lot of governance and be very hands-on in your design and how you're doing your token allocations. In the second example, they're going, we don't care what you do to the community. We don't care who you give other things to. We get our 5%, which was the benefit of our bargain, come hell or high water. And we don't really care. Good investors, that's actually the way they do it. And they go, look, if we went on this point, then we're not going to heavy hand you on the management and governance and covenants and that sort of thing. But when it's the first one, you're going to get a very robust governance package, including things like how you're going to license IP and all those sort of things. Because they won't want you to design around it. In the early years, it was primarily, and when I say primarily, I mean like statistically the most common to have the first construct, right? A percentage of the inside. I would say today it's flipped in the overwhelming majority or the more simple construct where we just agree to a fixed percentage of a fixed denominator. And so now the governance covenants in these, modern deals like what we're doing now is a lot less onerous than it used to be. But it all depends on where you come out on this. And I think you can see why, from a business perspective, investors would care more about the governance package in the former mathematical computations. Any questions on that or anything else with 3 minutes left?
I guess one additional point, and this is a live issue that I recently dealt with. If you do agree to grant investors governance rights or block rights over certain decision making, that can also run into some friction with the securities analysis. And so in the case with this specific client, and we've solved for this issue, but as part of the side letter that they entered into, the granted investors token rights, one of the things that the project agreed is that there would be specifically, I believe it was like maybe 20 to 30% of the total token supply would be used to incentivize users of the protocol. That 20 to 30% bucket is not actually going to be sitting with the DevCo, right? With the launch partner, the Delaware Corp. That's going to be moved over to the DAO legal wrapper. And the issue that we ran into is that once that 20 to 30% is actually sitting in the Cayman Foundation in this case, how token holders ultimately vote to use those tokens, how they allocate them, how they grant them, means that they could be granting less than 20%, or potentially more than 30% if there was a large treasury of tokens going over to the foundation. And so having a situation where you had investors of the Delaware Corporation potentially having a block right over the actions taken by the DAO was just this, it was a perverse outcome. And luckily in this case, the investors agreed, they waived the rights or the block right that they had on a permanent basis. But it's a situation that ideally you can avoid in the first place. I guess that as we wrap up, again, it's been a pleasure spending the last few sessions with you guys. I believe you should have the links to our bio and our email addresses. If any questions come up, we're available and happy to chat through any of this or any other legal questions you have.
100%. Just let us know if we can help unpack this. Be thought partners. We're always here.
Yeah.
Cool. Well, there's no other questions, and thank you guys for working with us here on this, and it's been super informative.
You bet. Thanks, everybody.
These were all great, guys. Thank you.